Welcome to this month's webinar. The title of the webinar is Intellectual Property in China, Legal Implications, Challenges, and Solutions. Before we begin today's webinar, I just want to make sure that the system is operating accordingly. If you could all raise your hands, if you can hear me, then it will let me know that the system is operating well. For your information, the presentation will be distributed at the end of this webinar, so you'll be receiving that today per email. If you do have any questions during this webinar, I will do a very brief Q&A at the end of the session if the questions are generalized. If the questions are very specific, then I will email you directly in regards to your cases and see if we can help you in any shape or form. For those of you that are new to Clayco Group's webinars, I will give you a brief introduction. Clayco is a family-operated company. It's Western managed. It's an international accounting and management consulting firm that was established in Hong Kong in 1979. We have over 120 consultants, legal professionals, accountants on staff. Our head office is based in Hong Kong, and our head office in China is based in Shanghai, and we have a further 7 offices that are located there. We also have an office in Singapore that does the identical services as we do in Hong Kong. Our main target are Western companies that are looking to enter the Asia-Pacific region, and we offer a variety of services that can help them in their establishment process. A little bit about myself. My name is Christina Kohler. I'm a director at Clayco Group. I moved to Shanghai at the end of 2003 and opened our office there. I've been managing our China offices since. I've been helping Western companies with quite a few transactions in China, everything from establishing manufacturing entities, joint ventures, trading entities, service entities, all the way down to liquidating them as well. I have gone through a complex M&A deals, merger and acquisitions, which are getting more common today on the market, and all the related outsourcing solutions that we can offer to clients, from accounting, tax filing, etc. I'm also co-author on our monthly magazine called ChinaInvest.biz. If you are interested in subscribing to this magazine, you can do so very easily on our website by just inputting your email address. So the topic for today is intellectual property. It's a topic that is generally not discussed or not even raised by clients during our meetings with them. And it was my thought to have an event, to have a webinar specifically based on intellectual property so that people can really understand what is the value of it, what needs to be done, and how you can possibly structure your intellectual property when you're coming into the China market. Now, the most common phrase used in China since decades is, if you can make it, they can fake it. Well, intellectual property protection is really one of the major concerns, but in my opinion, it's one of the major concerns that comes too late in the game for many of the Western companies that are deciding to enter the China market. The IP protection history in China is very short. For centuries, the Chinese people had not had any sense of protecting their own inventions or respecting the inventions of others. Not until 1984, which is really not long ago, it was when the Chinese government established its first patent law. The Chinese government has realized that creating a positive IP protection environment, it's not only important to protect the rights of foreign companies that are collaborating with their Chinese partners, but it is really critical to foster a creative environment in the Chinese market for Chinese companies themselves. Now, counterfeit products are everywhere, not only in China. Name any major branded product from software to cars to music to handbags to prescription drugs. There is a forgery somewhere in the world. Problem is that lately it has become more difficult to spot the fakes, causing a very serious competitive threat to foreign companies. And while counterfeit products is a worldwide issue, it is mostly recognized in China, which is home to almost 2/3 of the world's fake and pirated goods. The government, mainly through the State Intellectual Property Office, the SIPO, has made tremendous efforts to promote IP protection environment, and these include amending the patent law numerous times to make it more acceptable to the rest of the world, enhancing the law enforcement capabilities so that every county and city in China has a local IP protection office in order to more effectively implement the law. It has increased the fine and punishment for any breach of IP. So IP violation in China is considered actually a criminal action, and anyone who is convicted faces both fines and prison time. They've promoted the awareness and self-consciousness of the IP protection among the Chinese people through nationwide educational TV programs, newspapers, articles, etc. They've been collaborating with US and European governments to establish the IP protection guidelines, and they've invited foreign government officials and journalists as guest speakers at various IP protection forums that are also held in China. Furthermore, China has implemented its National Intellectual Property Rights Strategy in 2008, so this is now 5 years ago, which aims at improving the protection system, strengthening the law enforcement, and raising public awareness. Some of you may think that this hasn't really occurred, but there have been drastic steps in the process over the last 30 years since the SIPO was actually opened. For those of you, so actually intellectual property and the definitions of patents, trademarks, copyrights, there are all different laws in all different jurisdictions, and here I just wanted to explain to you what are the regulations, what are the definitions of these three categories in China. So a patent provides companies with an exclusive right to license or commercialize their patented invention, and there are three types of patents. There's inventions, utility models, and designs. If you apply for a patent in China, it is valid for 20 years from the filing date. This is for an invention patent, and for designs and utility models, it's 10 years. So the patent law also allows chemicals and pharmaceutical products and the processes for manufacturing them all to be patentable. Here's where comes the tricky part for many of the foreign companies that are looking to register their patents. When you need to register a patent, you need to provide the manufacturing process as well as the ingredients in a product, for example, a food and beverage item or a pharmaceutical product. In theory, when you're doing this application, you are already releasing information on your product to the SIPO. Now, in theory, there's a lot of cases where you would assume that you're protected. Well, in the early days of when SIPO was initially started, there were certain employees that did take this information and did set up fake products in coinciding with that. I do have to say that in the last 10 years of working with SIPO and working with clients and registering their patents, this has been less of the case. And if they have seen that anybody, one of their staff, has done any of this, it is a criminal action, and they are all sent to prison. So it is something that's taken very seriously. So if you are looking to register your patent, don't have the fear when doing the actual application that your products will be then already violated and put onto the black market. Copyrights. Well, unlike patent and trademark protection, copyrighted works do not require registration for protection. Protection is granted to individuals and firms from countries belonging to the International Copyright Conventions or bilateral agreements, which China is a member of. However, copyright owners, especially owners of software and foreign audiovisual copyrights, may, so this is, for example, movies, may wish to voluntarily register with China's National Copyright Administration to establish prior evidence of ownership. And this is only in case enforcement needs to occur, things like that. Now, the biggest work that we get in terms of clients handling intellectual property comes actually from trademarks. So trademarks can be defined as company names, phrases, logos, images, designs. Generally speaking, it's names and phrases. They represent products, services, and the background of a company, basically. If you register your trademark successfully in China, it is registered for 10 years. The trademark applications are divided into 43 separate classes. A class in China is considered a service or product category. At least one class should be specified when you're doing your application. More classes can be specified if you wish. The application is done in Chinese, and it takes approximately 18 months to file. And during the application procedure, the mark is not yet considered an intellectual property of the company, but in case of infringement during this time, a warning letter can be issued. And in case this is ignored, it is possible to sue once the application has been approved. Now, here is where the tricky part comes in China. It is highly recommended, and this is something I can't emphasize more, to register your trademark as soon as possible in China, because the regulation in China is associated to the first to register rule. So whoever registers that trademark in that class first is the rightful owner of the trademark, and they have priority over anybody else. Now, this is very important to note, but because of this regulation, there are tremendous trademark squatters out there that are registering trademarks of foreign companies before they even have the ability to register their trademarks in China. Now, to give you one example, there is the case of a Chinese logistics company that had primarily U.S. clients sourcing products in China and exporting to the U.S. This logistics company registered all of the trademarks of their U.S. clients so that eventually these U.S. clients could not even export their products from China. They were not even selling in China. They were just exporting from China for sale into the U.S. And because this logistics company registered the products, they were not even allowed to export the goods from China. And now they're going through legal situations. So even if you are just sourcing, producing your products in China, and you are putting your brand name on these products, and your packaging has your brand name, you've got to make sure that you're still registering your trademark. Trademark does not refer just to selling in China. It refers to all activities that you are actually doing in China, whether it be marketing, branding, sourcing, manufacturing, providing services, or even selling. You've got to make sure that your trademarks are registered. Now, trademark protection is advisable. I mean, this is the first thing you should do prior to establishing an entity in China, and it's especially important for SMEs whose trademark is really popular in their home jurisdictions. Marks which are recognized as well known, they can enjoy a special protection, and you can fight these trademark squatters if it can be proved that they've registered the trademark in ill faith. And of course, these trademark squatters are all attacking the SME brand names now, because all of the top brand names, the luxury brand items have all been registered already. Now, unfair competition is something that's talked about very little, but just to give you a bit of an idea, it does provide some protection for unregistered trademarks, packaging, trade dress, trade secrets. The Fair Trade Bureau, which is under the State Administration for Industry and Commerce, has responsibilities over the interpretation and implementation of unfair competition and the protection of company names. So if you do have trademark squatters that are utilizing your trademarks for ill means, this is where you would go in order to fight them. Now, how is enforcement in China? Well, although China has adopted various laws to protect IP, the enforcement of such laws remains problematic in the court system. and there's still a lot of reform that needs to occur. In 1998, China established the CIPO with the mission of coordinating IP enforcement efforts by merging the patent, trademark, and copyright offices under one authority. This has yet to occur. Today, CIPO is responsible really just for all the applications, for granting patents, registering semiconductor layout designs, enforcing patents, as well as coordinating copyright, trademark, and patent registrations. The protection of IP in China follows a two-track system, administrative and judicial. The IP rights holders may file a complaint at the local administrative office or a complaint in court. And administrative actions are far more common, although judicial actions have been increasing. Determining which IP agency has jurisdiction over an act of infringement can be confusing. Jurisdiction of IP protection is diffused throughout a number of government agencies and offices, with each typically responsible for the protection afforded by one statute or one specific area of IP-related law. There may be geographical limits or conflicts posed by one administrative agency taking a case involving piracy or counterfeiting that also occurs in another region. In most cases, administrative agencies cannot award compensation to a rights holder. They can, however, fine the infringer, seize goods or equipment used in manufacturing products, and or obtain information about the source of goods being distributed. So how is then the legal framework and tax implications? So now that you have all the information in relation to the actual IP law, the next question that comes about is, how do I actually handle my IP in China? And what structure should I implement, and what are my tax implications if I implement these structures? Well, the first structure is transferring your IP from an overseas jurisdiction to a China subsidiary or a holding structure. Many of our clients actually do not want to transfer their IP ownership to the China entity, but they would prefer keeping it in a holding structure in a tax beneficial jurisdiction because of the licensing fees that they will gain from the China entity. So in many cases, clients in Europe, they usually keep their IP in a Luxembourg structure. They have it held in a Luxembourg structure, or otherwise, if you're doing your business in Asia, you can have it under a Hong Kong or Singapore structure. The tax implications, if you are transferring your intellectual property to a China subsidiary, there will be a capital gains tax of 10%, which is derived from the IP sale, which will be withheld by the China subsidiary. And in addition to that, there will be business tax imposed. And in the near future, if you're not located, starting in August actually, it will be VAT instead of business tax, which is at a rate of 6%. But again, transferring your IP to the actual China entity, not highly recommended. The next option is the IP licensing. This is whereby the headquarters keeps the ownership of the IP and only transfers it to transfers its use to the China subsidiary. There will be a 10% withholding tax. Excuse me, ladies and gentlemen, I just lost the audio. I believe we are back now. So I'm back on the legal framework and tax implications. And I will start over because I'm not sure when the audio was lost. So the first option that you have is transferring the IP from an overseas jurisdiction to your China subsidiary. Now, many of our clients refuse to have their China subsidiary hold their IP directly. So what they do is that they establish holding structures to hold their IP. This is usually done in either Hong Kong or Singapore. If it's a multinational organization, generally the IP is held out of Luxembourg, Holland, or Ireland because of the tax benefits. If you look at Google or Amazon, most of their IP is held actually out of Holland and Ireland. There are tax implications if you're planning on transferring your IP from an overseas jurisdiction to a China entity. There is a capital gains tax of 10% derived from the IP sale. And in addition, there is VAT applicable at a rate of 6%. Business tax is no longer applicable starting in August because the VAT reform system will be spread throughout all of China. The other option is just IP licensing, and what this means is that the headquarters keeps the ownership of the IP and only transfers it for the use to the subsidiary in China. There are tax implications on these type of invoices. There's a 10% withholding tax on the royalty fee, as well as a VAT tax of 6%. Now, I do have a couple of clients who ask me, can they contribute their IP as part of the registered capital of the entity in China? Now, this is something I highly not recommend. Do not put your intellectual property as part of your registered capital. The Chinese government will need to evaluate your IP and need to evaluate the value of your IP. In order to do these evaluations, they will need to know everything about your intellectual property. If this is a design, if it's an invention, they will need to know the ins and outs of everything. As such, I would not recommend utilizing this method because in the end of the day, you do not know where all of these documents will fall. And there is no control system in that regard. There are tax implications, not direct ones, but there are tax implications, and this will need to be really detailed out what the tax implications are depending on whether there's a double taxation agreement between the home jurisdiction and China, basically. Now, there are possibilities of tax exemption, but this is really a case-by-case process and very much depends on the type of IP and for which industry. If you are in the high-tech sector, it could be that if you do transfer of IP or IP licensing, that the tax exemptions are imposed, but it's an evaluation process again by the tax bureau. Now, what are the best practices for your intellectual property? And I've listed here 4 items which I would like to go into more detail. The first are internal issues with your own China entity. Now, all of this may seem tedious to do. These are just recommendations. You don't have to do every single one, but it's just ideas on how to protect your IP. The first is run background checks on key employees and include non-compete and non-disclosure agreements in your contracts. Share IP information with employees on a need-to-know basis. Educate employees about the firm's confidentiality requirements and about consequences of IP violations. If you all have employee handbooks, then it is highly recommended that you put in what would be the violations if someone talks about your IP. Track data flows and file transfers, both paper and electronic, and closely monitor the entry and exit of flash disks, portable hard drives, laptops, sensitive paper documents. Know where the information is flowing within your entity. And this is something that's very hard to do, but if you do have an IT department, it will make things a lot easier. Control and monitor employee access to sensitive equipment and facility areas. So if you have a manufacturing facility in China, don't give everyone access to areas whereby you have research and development or you have the actual IP stored there. Conduct exit interviews with departing employees to recover any sensitive materials and remind them of the confidentiality obligations. Establish an internal fraud hotline. And again, this is really something for much larger companies. If you are an SME, then usually the manager, the general manager, should develop a close relationship with each staff so that they are aware that they can communicate with them in regards to any issues that may arise. It should be in the case if you do set up an internal fraud hotline, it should be something that your suppliers, your distributors, your customers, your third parties can all report in regards to counterfeiting or in regards to utilizing your IP. And build a database of company infringement cases and infringers and make it available to key employees across the company's China offices, as well as maybe globally even. Keep this information on hand so people are aware of the history of what has occurred in your China entity. External issues with suppliers and distributors. Well, the first is select partners with a demonstrated understanding of the value of IP, especially those with brand images and reputations of their own to protect. Conduct comprehensive due diligence on suppliers and distributors prior to any agreement and on a regular basis afterwards. Include IP protection clauses in all contracts and all agreements. You'd be amazed to know that many of our clients do not even have contracts and agreements with their suppliers or distributors. So the first step in any case is to have contracts and agreements and then just to make sure that there are clauses within it for IP protection. Manage your supplier, your distributor relationships through multiple personnel to limit the ability of local staff to abuse business networks. If you are an SME, this might be very difficult to do because you don't have the staff or resources to have multiple people developing relationships with suppliers or distributors. But try and do your best in regards to developing these relationships with multiple people so that you don't have all your eggs in one basket. Review information that could be sent to third parties before transmission to ensure that it is not sensitive or that the benefits of sending it out outweigh the risks of it being leaked. Again, this is very tedious work that needs to occur. If you are starting to grow, this will be the least of your concerns because you cannot check every single correspondence, email, letter, fax being sent out. But it's just something to consider. Control the operation processes. This is really in regards to manufacturing companies. You really should compartmentalize critical steps in the design and production processes for products involving IP so that no employee has access to all the information needed to copy the IP. Keep vital designs, latest generation technologies in your home jurisdictions, bringing only to China what is needed and what makes business sense. Classify information according to IP sensitivity, laying out which employees have what level of access to the information. Consider incorporating into the production process technologies and techniques that are difficult to copy. The last one, this is just a consideration. If you are an SME, I wouldn't do it. But for multinationals, they tend to do this. Search for cases of infringement in the China market. This can be done sporadically. And you can have someone doing it for you or you can do it yourself. Send representatives to visit trade fairs, such as the Canton Fair, and look for counterfeiters. We've had many clients who've gone to the Canton Fair or who did not go for a couple of years, and they went again and they all of a sudden found products of theirs, designs of theirs with different brand names on the shelves. Review distribution networks at all levels regularly for any types of weak links and possible entry points for counterfeit products. Check the internet regularly for infringing domain names, for websites that are used as platforms for counterfeit products. These include the online sales sites such as Alibaba and Taobao. I can give you an example here. I have a U.S. client that produces a baby product, and she unfortunately put all her eggs in one basket and had only one supplier in China producing the product. She wanted to start selling the product in China, and she had a staff member actually do a little bit of research on e-commerce in China, And this staff looked on Taobao and found the product on Taobao with the label removed. So, you know, these are very simple and easy things to do if you are based in China, or even just from overseas, to set up an account with the online e-commerce platforms and check if your products or designs are already available. There are easy search engines on these platforms that make it very easy to search the products. So that's the end of today's presentation. You know, there are numerous internal and business policies that companies can undertake to reduce the exposure of IP misuse in the first place. And, you know, these include IP control, non-disclosure of trade secrets and know-how, careful selection and monitoring of business partners in China, including distributors, licensees, suppliers, and avoiding to utilize business partners that you don't trust or that have no sense of what IP really is. Although this may all make the market penetration more difficult, it will actually make your life much easier in the long term if you develop these internal policies and have these established and in place in order to protect your rights and your businesses in China. It may be very tedious work to do when you are a startup and you're first starting your business in China, but really in the long term it will pay off. It is advisable for companies to seek advice in regards to IP specifically before it's too late, both in your home jurisdictions as well as in any market that you are working in. Now, for some of you who are not too clear on certain IP regulations, there is something called the Madrid Protocol, which has approximately 50 countries listed within it, and you can do one simple application and have your IP protected in all 50 countries. China is included in that, as well as Hong Kong, Singapore, and various other Asian countries. This is just a advice if you want to do it all in one lump sum, but of course you can also do the applications individually. So if you do have any questions, then please do let us know. And I have a couple of questions here that are very specific, so I'll answer them by email at the end of this presentation. Again, if you have any questions, please don't hesitate to email us, call us. We're more than happy to help, and we look forward to seeing you soon. Thank you all for joining us, and have a lovely day. Goodbye.